Welcome to the program, Lateral Moves and Model Rule of Professional Conduct 1.10. My name is Tracy Kepler, and I will be with you for the next hour speaking to this topic. So where do we start? The stars have all aligned. You have an attorney position to fill, and you've found the perfect candidate with the right credentials, experience, and book of business, who clears the initial conflicts checks, meaning the review of clients and matters on which the attorney is or was actively working. The attorney, looking for more interesting and meaningful work, better opportunities for advancement, and a better financial position, has accepted your offer and is ready to start work. Your firm knows the value of having screening mechanisms in place, but even with all the T's crossed and the I's dotted, the potential for a conflict of interest may arise. How can your firm implement an effective conflicts of interest screen and have some comfort in its effectiveness if and when the time comes to defend against a disqualification motion? At the end of this program, we hope that you will be able to understand the purpose of conflicts of interest screens, identify and comply with the provisions of Model Rule 1.10a, and we are looking at the model rules here. Every state's rules do differ, and also learn the elements of an effective screen. Ethics rules are used in order to avoid imputation of disqualifying conflicts of interest in a number of situations. The ABA Model Rules of Professional Conduct permit the use of ethical screens to prevent imputation of conflicts where a disqualified lawyer has moved to a law firm from a judgeship or other decision-making role, and that rule is Model Rule 1.12, or the disqualified lawyer is moving from a private firm to government or vice versa. That's Model Rule 1.11. In addition, Model Rule 1.18, that talks about prospective clients, allows a firm to prevent disqualification from a prospective client when a law firm receives confidences from that prospective client, but ultimately does not undertake the representation of that prospective client, providing the screening requirements of the rule are met. Most recently, 2009 amendments to Model Rule 1.10 permit the use of ethical screens to prevent imputation of certain conflicts when a lawyer moves between private firms and the disqualifying conflict arises from work done at the prior firm. We're talking about the former client rule, Model Rule 1.9. So what is the purpose of conflict screening? The purpose of conflict screening is really threefold. First, to assure the affected parties that confidential information known by the disqualified lawyer remains protected and is not shared. Second, to prohibit the disqualified lawyer from participating in the matter at issue. And third, to ensure that other employees of the firm who are working on the matter do not communicate with the disqualified lawyer with respect to the matter. It is important to remember that ethical screens do not remove a disqualified person's conflict of interest. Rather, they are intended to form a cordon around the disqualified person or persons, and then avoid the operation of the imputation rule from causing the disqualification of the disqualified person's entire firm.